Yeah, good afternoon, students. Today also it's continuation of yesterday's class, and I need to cover the topic is today's topic is the Industrial Dispute Act 1947. So this is the same year where India is got independence. At the same year, this Industrial Disputes Act was 1947 as enacted, as also implemented for the purpose of to address the various issues like why these causes of conflict between employer and employee or employer employee, like, so what are the consequences, what are the causes for disputes related to wage, related to timings, related to working hours, okay, related to what we call promotions, like various reasons are there for the conflict. Is any kind of mechanism is there to address these conflicts, like, so conflict between miscommunication between employer employee and it leads to strike or loss of productivity. Definitely if it is no the peaceful environment within the organization or within the factory, so we can't uh, expect the good kind of production system, and the productivity is also the limited, and because of there is no harmony within this firm, so uncertainty also it leads. Then how to address these kind of disputes, industrial dispute, through what kind of mechanism is there, or structured procedure is there, anything, or conciliation officers can be appointed, or arbitration process can be there, or judicial interventions are required. So that kind of mechanism will see the next class, and harmony is required, and stability is required for resolution. See that these are the dispute, these are the sources of resolve the issues. Then so the first pillar, what we think is to understand the blueprint. What is the objective or the purpose of this Industrial Disputes Act 1947? And this act, purpose this act is very clear to giving a better environment within the organization, and without any kind of conflicts that leads to increase the company productivity, the employer and employee good relations. This also helps the firm. Both are happy. Then who is an employer and employee is also defined. The definition we'll see. And what are the causes of disputes, and how to what is the causes for strike and lockouts and layoff or retrenchment in the eye of in these lines of this law. Okay. Then what are the two core components, and what are the parties are involving here conflict? First, so as per Industrial Dispute Act 1947, the Section 2, subsection K, define the disputes differ between employer and employer, employers and workmen and workmen. There are three maybe conflict between these three areas: employer, employees, workmen, and workmen also. So these disputes must be concerned with the employment and related to non-employment in terms of employment or conditions of labor, or any person or individual work, dismissal, discharge, and retrenchment. Anything can happen, and the causes can be mentioned in the section 2, subsection A, as per Industrial Disputes Act 1947. Then second one is who is workman. So section 2, subsection S of Industrial Disputes Act define any person, including an apprenticee also treated as employee, apprenticee also an employer, employed in any industry to do any manual or unskilled, skilled, technical, operational, and clerical or supervisory work for a hire or rendered his services. But so there are some not included under workmen, like individuals in the Air Force, Army, Navy, Police Service. These are very essential for security, internal security as well as external security of the nation. So not included in the workmen. And these employed mainly in a managerial administrative capacity. See the top level people not comes under this workmen. And the supervisors drawn the wages exceeding the specified amount. So they also not covered under the workmen, like the employer. So employer defined in the section 2, subsection G of Industrial Disputes Act 1947. in relation to an industry carried by any by or under any authority. The Department of Central and State Governments, an authority person specialized in the department, they are mentioned in this act. And then we see that what is a strike? The strike is defined in the section 2 subsection Q of Industrial Dispute Act. A seasons of the work by a body of persons employed in an individual acting in a combination are concerned refusal to work. They are not ready to work. Everything is available. The employers are ready to provide the work, but employees are not ready to work. And as per this section 2 subsection Q. So this is the weapon of these employees. But employer has also some uh, weapon. The temporarily he will close the place of employment or suspension of work. The refusal by the employer to continue to employ by the number of persons employed by him. So so this is the weapon of the labor workman. This is this weapon of this uh, management. So management can also can take this. No, they are not ready to provide this work for the employee. They are ready. They are ready to work, but the management not providing the work. But here you can see that the employer ready to provide the work, but the workman is not ready to do the work as per this section. So what is layoff? So see that the failure and refusal inability of employees to give employment for workmen whose name is no like roller due to shortage of coal, power, and raw material, accumulation of stock, the breakdown of machinery. See that sometime as per section 2, subsection KKK of Industrial Dispute Act, the layoff can be the management can take the decision, right? The workman is ready to do the work, but because of raw material shortage, because of power cuts, because of there is no demand of stock and breakdown of machinery, some cases the management can lay off these employees. Mean they remove. Recently, we have heard the word after AI, these Google and Microsoft and even Tata's are lay off the employees because of the employees are ready, but the management unable to provide this work. So this is covered in the section 2 subsection KKK in Industrial Disputes Act 1947. Then section 2 subsection OO of Industrial Disputes Act retrenchment, the termination by the employer by the service of workmen for any reason, whatever other than the punishment inflicted by way of disciplinary action. It does not include voluntary retirement, superannuation, termination due to non-renewal contract. Other these treatments also the management can take for this the employee to remove these employees within the organization. So now the pillar number 2, the disputes revolution machinery. Here you can see that if the disputes are there between the workman, employee, and workman. So cases, what are the hierarchy to resolve these disputes as per this Companies Act, as per the Industrial Disputes Act 1947. So here it says that there are hierarchies there. The first one is workman committee. To address the issue, the workman committee appointed at the ground level and by parties formed to resolve the differences. If any differences are there in between these workmen, so the ground level, the issue will be resolved within the ground level for by party. Both parties sit together and they will discuss. They can resolve the issue as per this act. Then, if this works committee is unable to resolve the issue. The second one can be conciliation officer, the first step in the state lead mediation. Like this state level officer is appointed for conciliation purpose and he will investigate what the purpose, what are the causes are there. So like he will take initiation, the conciliation officer appointed, works committee is unable to solve the issue. Then sometime the conciliation officer is unable to solve the issue. Then what the third step is the board of conciliation officer. So the more formal tri-party conciliation body. So this is tri-party conciliation body. The body consists of the workman side and management side, and also other third parties also involved here. Board of conciliation officers are there. They will sit together. They will discuss the company's issue. Both sides they will try to resolve the issue of this organization or industry. Sometimes even the board of conciliation officers unable to address the issue, then maybe the next level can be court of inquiry. The fact-finding bodies for complex disputes, the court are legally entered in the organization disputes. They try to resolve, and they also appointed investigation officers like labor court and industrial tribunals are there, national tribunals are there to address this Industrial Disputes Act at this level, whatever these disputes or levels are there. Now, the first one is what we call, we go for first see the down level, the works committee. The works committee is appointed if the establishment or factory employs 100 workmen, 100 plus workmen are there. So comprises equal representation of both employer and workmen to promote measure of securing and preventing amity good relations. The workman is appointed for this at the ground floor to address the issue if the employees or workmen are more than 100. Okay. So then the issue is not occurred, then go for conciliation officer. The disputes that the government will intervene to mediate this, promote settlement, try to address. Then board of conciliation officer, as I told you, the two tri-party, 2 or 4 members other than representing the parties also they are including here. The second level. The third level is, as we discuss, formal judgment for upper floor court of inquiry. The court of inquiry they can be either a labor courts or industrial tribunal or national tribunal. Here also the address can be the issues can be resolved. The rule engagement, you see that the third pillar of engagement, the best architecture designed to failure are not just within this standstone. So the key function of this rule engagement, what we can say that here preventive design. So here proactive proactive tool designed to ensure fairness, communication, and early resolution grievances they can address here. Managing high-level stress within the organization, the both side, employer-employee strike and lockouts, other major actions can take. Here, the risk can be resolved to address the issues. And noise of change. Here, what we can take is if they want to go any kind of uh, thing they want to take, the employer can take chance to conditions how the specific in fourth schedule like working hours related to wages related to leave related to. So like retirement, the chance can be 21 days given for the notice. So if they go for any kind of that, they give to notice for 21 days. So grievances redressal as per section 9 and subsection C, the committee can be appointed within the resolution can be complete 13 days or they can appeal for employer, whatever the due dates are mentioned. Then the managing high level stress event, regulatory strikes and lockout. So try to what we can avoid these strikes and lockout. Like there are general utilities, public utility services are there like railways, power, the banking sector. Okay. And these are not allowed to do the public utility services. Like we heard the name in the name ESMA. The state government will declare ESMA to remove the employees without any kind of notice. All these we have heard, we have very witness in the case of RTC strike in Telangana and what kind of steps taken by these Telangana government in KCR period. At the same time, the big debate in Tamil Nadu, the Jayalalitha, the chief minister at that time, she removed most of the employees, those are going for strike. And even court is also intervened. The court also said that you have to discuss with the state government. So like they are can't allowed for all the situations in public utility services. No person is employed under shall go for strike without giving the employer notice within this strike within 6 weeks before strike. Strike within 14 days giving such notice has to, whatever the notice they give, they need to go for strike within 14 days. The strike before the expiry date, specific notice to be given. That's what like workmen are given this kind of situation. So the last one is upholding the blueprint. Here this the unfair law practices within the red lines, either employer and employee is taken care. legal consequences are there. But as per your examination point of view, you will understand the mechanism for redressal of industrial disputes. Okay, the example of fair labor practices are there. See, they're in the form of joint sit together, avoiding illegal strikes, illegal all this. Then penalties of if it is go for uh, without proper procedure, illegal strikes, illegal lockouts, there can be a penalty can be imposed by this legally. So, like here, Industrial Disputes Act more. So you need to understand in a proper way for this labor laws, Industrial Disputes Act. So after that, we have moved to one more block in our syllabus. We need to move one more topic. Now we move to block number three. Under block number three, we have four topics are there, four units. One is Payment of Wages Act 1936, Minimum Wage Act 1948, Payment of Bonus Act 1965, and Equal Remuneration Act 1970s are there. We'll discuss one by one. First, we'll move to legislations on wage and salary. First, we'll go for Payment of Wages Act 1936. Payment of Wages Act 1936, we'll go to Payment of Wages Act. Okay. Payment of Wages Act 1936. Payment of Wages Act 1936. And here, so here what we can do is there are n number of organizations. There is different for their business process, their what we call their working culture. The timings are different. But we as a country, we require a uniform payment system is required irrespective of organizations, right? Either and before 1936, before this minimum wage act, what are they see these arbitrary deductions are the employee could make deductions from the earned wages without any justification. So, like the management can reduce this, no, they're not giving the fair wage, so their deductions are more. Unpredictable pay days, the workers face significant delays in receiving their pay and causing, as the employee will receiving every month 31st salary or first January or first February will get a salary of first week every month. But before this act, there is no this kind of time periods are there. The employer, the workman can get the salary irrespective of salary or wages, irrespective of date. As per their management interest, they will get the salaries. There is no specified time period mentioned. And under unregulated fines were imposed for the both side if the workmen are not, the management not pay the time in time salary. There is no legal bond, legal provisions are there. But this act is try to resolve the issues, whatever the issues are there. This act, the payment of a 1936 was enacted by this see that to ensure wages are paid in a particular form at a regular intervals without any unauthorized deductions. Here deductions are there. Here try to reduction. So regulate the payment of the persons to provide speed and effective is there. Then who are covered under? So as per this Act 1936, the Payment of Minimum Wages Act, the Act applies to persons employed in a factory or railways, administrative other than industrial commercial establishment. The state government may extend its provision to other establishments also as per their own purview. So this act apply to employees whose monthly wages do not exceed 24,000 as per the new notification given in 2017. So what is the ceiling here? The 24,000 per month. They are under this act. So what wages includes? What wages includes? What are the wages excludes? So wages includes remuneration from awards or settlements, The payment of include the pay of overtime, the holiday amount is also there, and leave period, additional remuneration under any employment terms like bonus, and the termination dues, retracement notice also, whatever the payment, any sum of a scheme formed under this law is covered under wages. So what are the exclusion? So sometimes the value of house accommodation, sometimes the company may provide the accommodation and the providing with the house they provided along with the lighting, water, and the company may provide medical treatment. Medical treatment also it's also covered. So employer contribution to pension and provident fund is not included in wages. The traveling allowances, the value of travel concerns is also not included, and the sums paid to cover the special employment expense also not covered. The gratuity payable also not covered under wages to compare the inclusion and exclusion of the wages. So as per this act, who is the responsible person for payment? A specific scenario is given here. Factories, the manager he has to, he's a disbursing officer, he has to pay the wages. Or in some industries establishment, the person responsible for supervision of this work nothing but HR will decide of establishments. In the railways, nominated person will disbursing officer. In case of contractor, the contractor itself is a disbursing officer for this payment of wages. And ultimate responsibility for this employer, irrespective of this employer of all the cases. So employer has to pay wages to employees. So here, the how often must be paid to wages? As per Section 4 of this Act, the Wages Act, the wage period, every person has responsible for payment of wages must fix the period. It may be 1 week or 1 month, right? So the golden rule is no wage period shall be exceed 1 month. Right? We can't pay 3 months at a time base salary. We have to pay every month salary. Right? We can't say that I will pay salary consolidate 3 months once. No, it's not. It is not suitable for this act. They have to be punished. So maximum 1 month. Okay, as per this, as section 4, as per section 4 of this act. Then the payment of like the payment when they must be paid. The paid scenario, see the if the employer railways, factories or industrial establishment, the employees are more than 1,000. Employees are more than 1,000. So before 7th of every month, they need to get salaries or wages. So what is the due date? So January month salary, they will get in the month of February before 7th. The due date is before 7th. Okay, before 7th. Now, as you can see, the other than railway factory establishment, if the establishment employees working 1,000 or less than 1,000 or less than 1,000, the deadline before 10th of next month. So January month salary will paid the February month on or before 10th after the last date of wage period. See that January month 1st to 31st January I worked here. Then I am eligible to get a salary if the employee size is 1,000 or less than 1,000 next month of 10th. The scenario 3, the employment termination, the deadline. Wages must be paid before expire the second working day from the day out. So if the employees are removed, terminated, the second working day must be paid the total amount. So like here, it is given to this definition as per this act. Okay. Then, so method of payment of wages, how the payment will be paid, either cash, all wages shall be paid either currency coin or currency notes or both. So previously, there is not that much of online transaction bank payments. Previously, even government employees will get the cash. The treasury where this principal wrote a check and they will go the treasury and they will get the cash and cash will be disbursed. But now there is no cash transfer. Directly the amount will be paid to head office to all these employees. So now after certain period, the check is issued. The employee will go and deposit the check in their respective branches. And after they will get amount will be transferred. Now the DTB is there, direct bank transfer, DBT. All employees may pay wages by crediting them in a bank account. So condition check or bank transfer, this required written authorization of employee person. So here electronic payment system is common, act is employees. This is there now. Okay. Now this protecting the wage permission reduction, the management can also deduct some of the amounts for the as per this act. So the core principle of this act is the wages of employee person shall be paid without any reduction or any kind of exception, and these explicit authorized by this Act 7 and subsection 37 to 13 of this Wages Act. So the fines can be imposed as per section 8 of this Act. Right, the process is also there. The total fine of any wage payment cannot exceed 3% of wages. So cannot be exceed more than 3%. The minimum limit is 3% only. So unauthorized absent from duty, unauthorized. So reduction is absence from these places where the employee is required to work. So that reduction must be proportionate of the period of the absent. So if unauthorized is take leave, is not informed priorly or he not put anything in unauthorized options, so the appropriate amount can be deducted. Sometime as per section 10, as per this act, so within the working place, working areas, if he damage or anything lost by his negligence or his innocence, anything that for damage or loss goods into the employer lost money with their accountable. So this is there. Then house and accommodation deductions permissible if the employer provide accommodation. So as per this Act Section 11, this amenities, water, electricity supply can be deduct, and recovery advances, if anything amount can be paid through the loans and advances, they can also adjust. And other authorized reductions also, they can deduct like income tax, reduction from any order, court of orders, or reduction can be subscription from the provident fund, reduction from the payment to cooperative societies. Like, no, as employee, we paid every month some group insurance amount we paid, and we paid income tax also reductions every month, right? Subscriptions also for general insurance, what we call AP, TSGLI. We authorize the government servants. Then the golden rule of the absolute limit for deductions cannot be 50% in normal circumstances. The total deduction cannot be exceed more than 50% of wage. So where sometimes 70% can deductions are made whole party, the payment co societies, the limit can be raised these cases. Then the fines also not exceed 3%, and this absent period can be damaged, and house rent can be deducted. All is mentioned here in a statement form. Then the duties are maintained. They need to maintain proper the how many days wage paid, how much amount deducted, and what is rate paid. All the mentioned in a specified format of this level. So the climbing of appeals if the process, if the company is unable to pay proper wages, salaries, then we need to approach the proper uh, higher officials, what we call legally also we can proceed. So within 12 months of the date of deducted, the amount has to be under. So higher authorities are there. We need to approach this court or they we need to get our amount. So like if anything delay in payment of wages, making wrong deductions, or failing to pay wages on termination time limit after that. So fine which will not be exceed 1,500 rupees, but will exceed 7,500. Mean the penalty can be imposed. These kind of action offenses are there. The minimum amount is 1,500, the maximum amount is 7,000. In between, the penalty can be imposed. They need to penalize this amount. So failing to maintain register record and willingly refusing to provide information. So it is also fine can be imposed same 1,500 above and 7,500 below. So willfully abstracting the inspector and discharging of their duties, the fine which may exceed 7,500. So if the being convicted the same offences again, this amount 6 months and above 3,750 and 22,500. So penalties are designed to be a different So proactive complaints are always more cost effective than this facing legal actions. So like we assume that the formula can be here they mentioned how the salaries are calculated. So monthly salary 15 days. He monthly is 15 days. Monthly salary 15 days. He worked 15 days. The total working days we see that we excluding for these holidays. 4 Sundays are excluded. So then this month, so like his salary is 11,000. Some amount is there for these calculations. So daily is also we can calculate daily wage. Okay, excluding these holidays. Then the pay on time, every time they need to pay either 7th of next month or 10th of next month. So if it is any termination, the next second working day has to pay these wages. So deduction limit, they cannot exceed more than 50% and sometime it may be exceeded to the up to 72% over limit. And they need to maintain proper records and registration or registers all these. And respect procedure has to follow this case. Like now we covered this topic of minimum payment of wages act. So after this we go for one more act as per our syllabus. Okay, we need to go minimum wage act. We go for minimum wage act 1948. Minimum wage act 1948. I think my screen is visible. Minimum wage act 19. Minimum wage act 1948. So this is this our next topic as per this our syllabus. Okay. So the minimum wage act 1948, very next year after independence, we have to the employees minimum to get the salary, wages, and fair compensation as per this our right. So why it is necessary for the minimum wage, right? So previously we see that the most of the organizations are not paid the fair wage, so under wage, and there is no overtime, but they are not amount paid. Steward labor is there. So this act purpose to prevent the exploitation by establishing a legal and wage floor, ensuring every worker receive a wage sufficient for their substances and prevents their efficiency. This fame weighs not just in a business expenses, but is a matter of social justice. Is a matter of social justice. So this act, 1948 acts enacted, and this act is applied on entire India and designed to promote welfare of laborers. The objective of this minimum wage act to provide for the fixation of a minimum rate of wages in certain scheduled employees, the scheduled employees, I will tell you, to prevent the exploitation of workers through this payment of under low wages. So if the management unable to pay fair wage, they are paying lower wages. We need to address as per this minimum wage act. So employer, the government to take steps towards the fixing a minimum wage and review and revise then periodically. So as per this recommendation of labor commission, or they can appoint authorities as per this inflation rate, they need to revise these minimum wages, both central and state government in a renewal period. So here the object is fixation of wages, prevention of exploitation, and relief and revise the wages as per the periodically. Then what does this act covers? So this act cover the scheduled. The act applies to employment specific in a schedule of act. So agriculture, construction, factory industries, and textile. This covered. This the scheduled employment. Scheduled mean they have their name in mentioned in a schedule. So it is an employment specified in an act schedule or a process or branch of work format such employment. Initially, it includes 12 agriculture, 12 and 12 other industries. The government has power to add more employment and schedule. So here, the appropriate government, maybe state or central government, may choose not to fix a minimum wage for scheduled employees if it is fewer than 1,000. If it is lower than 1,000, it take the entire state. However, the number of employees later raised more than 1,000 or more, the government then required to fix a minimum wages as per this act. So, any act, what we can do is first we need to understand this definition of very key words, very important words, like the wages. So, wages what it include house and allowances. So, as earlier also I talked about you this exclusion of this wages, right? The second one is employer, right? The employer, the factory owner, or sometime government, sometime the responsible person for this employer as per section 2, subsection E. Employee, any person is employed in a hire or reward to pay either skilled, unskilled, or manual or clerical is also in a scheduled employed. Okay. And scheduled employed, the employee specified in a scheduled act as per section 2, subsection G. And age classification, child has not completed their age until 14 years, and 14 to 18 year adolescents, and about 18, after 18 we say that adults. The how the minimum wage is fixed and revised, the two official methods are there, is approved, and every 5 years the appropriate government must fix and revise minimum wages rates, and it will not exceed 5 years. This is done through one or two methods. So first they will appoint a committee, the government appoint a committee and subcommittees to hold these requests. So then this committee will sit together, will take time will be given. They will study the economic conditions, inflation rate, and previous committee recommendations. And then they will ask for the opinion of these employees who is working there, what are the concern, all this. Then they submit a report to the government. They will take a decision of this either what kind of fixing about this, and then they will given a official gazette. This is one method. The second method, method two, is publish proposal. The government publish it proposal for fixing or revising minimum wage of official gazette. Then invite objections. So if the government will issue notification, then call for any objections within 2 months of time. The interested parties to submit their objections. So after this receiving the objection, the final consultation will conduct all the observation and advisory body. The government may fix or revise the wage rate as a final notification. Okay. Here, what are the components of minimum wage? The component minimum is basic plus DA. Okay. What we call DRM always, the DA is included in this basic pay structure A. Sometimes basic pay plus the cash value consensus, it depends upon the nature of the organizations, if they provide subsidized food or providing medical health or anything. So, all inclusion, third one is that combines basic rate, cost of living allowances, and cash values put together. This is third wages includes. And now there is how to calculate the overtime, right? Overtime. So, if an employee works on any day more than the specified hours, so it is called OT, overtime. Okay. So as per section 14, the employee must pay every hour of overtime as a double or ordinary rate of wages, double of ordinary wages. So suppose if they paid hourly set amount, they need to pay double amount for works OT hours. So means the basic wage plus allowances of employee must be claimed for this ordinary rate. So HR is a responsible person to track this amount. Okay. Then working less than a full day. So if employee working less than full day, suppose this that does not apply for this failure of work site, cause my own willingness to work, but not employee. See the employee is ready to work 8 hours or 9 hours time, but due to shortage of material, due to shortage of power cuts, but they won't do anything long. They will get a full pay amount one day. The second scenario, performing two or more classes of workers, employees. So this is also you can see that sometimes piece rate based on the performance. So no less than the minimum rate. So if it is minimum rate also they need to follow. Then ensuring compliance are power of inspector. So, as per Section 19, the government appoints inspector to enforce the act, to inspector to power, enter and inspect the premises, hours, working hours, the scheduled employees number, and examine the persons. Are they is believed the employees are properly get salary or not, and they demand records to require the production of any register wages and record of employment of the document he will verify. And if this is no document proper, they can seize the document, and if they are not charged for manipulation of this and exercise other powers also will be given to this uh, appointment inspector. Then if what happened when the wages are not paid, right? What if wages are not paid? The employees work, but they are not paid the salary. What we can do? The employment themselves, a legal inspector, an official register can be trade union can be inspected. So the within the application must proceed the 6 months from the date of wage were due. So delay must be these are these possibility. The 10 times the compensation can be paid 10 times, okay, if they are not paid in time. And violating the provisions. So these are the cases are there. They're paying less than the minimum wage and rule of order. The penalty is also mentioned as per this act. So, like we can take hospital versus state government. One of the case here. So here, so how the case is mentioned in this place. Okay. So social welfare override state is also mentioned. One more case, and HR professionals like you, and you have to take care and you have to understand all the legal procedures regarding the Minimum Wage Act 1948. Okay. So this is regarding to our Minimum Wage Act 1948. Then we move to our one more topic in our syllabus. Okay, one more topic. Wait a minute. Right. Now we have one more act regarding to wage related. So that is bonus. So bonus is a gift or rights. So decoding Employment Bonus Act 1965. Right. So here what we can understand is the bonus. So is additional payment to the employees. Right. So here what we can do is based on the performance, based on this good productivity. So the before act, the bonus often this who will take as the employer or employee. Uh, there is a conflict. So there is no standardized method for calculation of or statutory right for the employees to claim their in profits. Right. So there is uncertainty and damage industrial peace, and it is also economic growth. Economic growth. So, like, what are the core objectives of this uh, core objectives of Bonus Act 1965? So, first one is to reward employees to improve a statutory liability on employees to pay and bonus employees for their contribution towards its success, and to share prosperity to provide the employment of bonus and the basis of profit and on the basis of the productivity. Right, the bridge the gap. These try to bridge the gap between employer-employee and to promote peace within the organization. So these are the major four objectives of this the payment of bonus acts. Okay, then so who will covered under this act? Right, this act applies the whole India, but it covers factories and every other establishment within 20 or more employer persons engaged any day during the accounting year. Previous accounting year, if a employee is more than 20, they are eligible for getting this bonus. But establishments include all departments, undertakings, and branches treated as per bonus computation unless a separate balance sheet maintained. Like there are a number of branches are there. So it's one head office preparing this, consolidating this balance sheet. So here they are not included. The bonus, all the operations not included. Other than this, like insurance are not included, LIC, RBI is also not included, and universities, education institutions also not included. The hospital, chamber of commerce, and social welfare institution and establishments also not covered under this act. Then this definition, as I told you, the definition is very important for read any kind of act. So as any person, so the salary not exceeding 21,000 per month. So they are eligible for get this bonus. So employment can be any skilled, unskilled, or semi-skilled manual, supervisional, administrative, technical, and clerical work for hire and reward. These are eligible, but their salary may not be more than 21,000. And the definition too, as per Section 2, Subsection 21 of a Minimum Payment of Bonus Act. So basic salary and dearness allowance are included here, and other allowances like HRA and the OT, employer contribution to pension, provident fund, and travel expenses are not included in this calculation of these wages. And the accounting year may be closed with every month, 31st March, the April 1st to 31st March in every year. Okay. So now these HR, the complaints like subject to the salary calculation bonus, how to include? So they include basic plus DA and exclude for HRA traveling allowances RV are not included as per section these. And then the what we call start with gross profit. How to avail what is surplus profit here? We need to base the surplus profit only. The organization may pay this bonus. Start with gross profits and as banking company scheduled. Then subtract the primary charges like payment of income tax and accounting area. The result will be the available surplus amount. So based on the available surplus amount, after meeting all kind of expenses in an organization, available profit distributing after accounting essential bonus cost like tax other they have to be paid. Like available surplus, 67% comprise other than banking made arrangement to declare dividend in India. So dividend to be declared and 60% slice they can be cases foreign company they can do. Right. So this is the total fund from the bonus for all eligible for employees who paid in an accounting year. Right. Then who will eligible? The eligible is 21,000 salary, only basic less DA, and excess are not eligible. So they have to work not less than 30 working days in that year. So he has to work minimum 13 days in a year, they are eligible. So how to calculate 30 days required, including these days, leave and salary or wages, layoff under the Industrial Dispute Act, and absence due to temporary is also included. So ground of disqualification is also possible, fraud, act related, the employee business, and these are some cases disqualification of this bonus. The payment of minimum and maximum, the section 4 says that the amount 8.33% of the salary of wages during the accounting year or 100 rupees, whichever is higher, for employees under 15 years. It is rupees 60. So this is clear 8.33. So maximum bonus, this is a minimum 8.3, the maximum is 20% of the salary base earned during this accounting year. Minimum is 2.8.33, maximum is 20. And genesis of this act, set on and set off. The long-term stabilities, like the maximum is 20, the minimum is 8.33 is there. See these, suppose you see the examples here is clear. Okay. Ensuring compliant deadlines and dispute resolution, the limit we mentioned here. And HR, like HR compliance checklist, putting app these practices, the set of all this registration. Like the legacy of this act, formula for peace, prosperity, and process. So, like the whatever these profits are there, both parties they can share for this, and the prosperity is there for good relations, and go for this profit. Okay. So, like we covered, there are four acts in today's session. Started with the Industrial Disputes Act and ended with Payment of Bonus Act. Okay. So next class we are going to discuss the remaining acts in our labor law paper. Okay. So this paper is very important. Like HR, they can understand this process and the definition, the procedure for calculating the wages, and all are important for this acts. Okay. So I will stop here. If you have any doubts, and you can contact me. I will share my number through my here. Just you can check. Okay. 9052771299. You can contact me if you have any doubt in this paper, labor law paper. Okay. Thank you. Thank you all. Have a good day.